Yo, YouTube, what it do, man? I'm back with another video, back with another reaction. Apparently, the Young Thug judge has been recused. You know what I'm saying? I kind of already knew that was gonna happen. You know, it was just a matter of time. But let's get into this video.
Judge Glanville has
Let's see
been
what he's talking
recused from the Young Thug YSL RICO trial. Judge Shakura L. Ingram is now presiding over the case. Glanville's gone, boys, and we got a whole new judge on the case. This is good news for the defense. I'm sure there's going to be some motions to dismiss because of prejudice, obviously. The audio on every video is now on Spotify and Apple Podcasts if you guys can't watch the video and you just can only listen to audio at work or something. I'm also going to be doing one bonus video a week on the membership, so hit the join button down below. All right, here we go. State of Georgia, order on motions to recuse Judge Glanville. This case is before the court to consider various motions to recuse, including defendant Yak Gotti's motion to recuse Judge Glanville, Caleb Bumpus' motion to quash the show cause order and order to recuse Judge Glanville, defendant Jeffrey Williams' motion to disqualify and recuse Judge Glanville from all further dealings in an above referenced case, an amended supplement. The specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. Having considered the record evidence and applicable case law, the court finds as follows. Findings of fact. Okay. These recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney's Office alleging gang activity and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7th. The motions to recuse all arise from the same circumstances related to state's witness Kenneth Copeland. On June 7th, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony, counsel for Mr. Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland, forced immunity that if he pleads the Fifth, he's going to be jailed for the rest of the trial, and they threatened him with jail time for years on end. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Glanville also advised that if asked, Glanville would jail Mr. Copeland for refusing to testify. After that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Oh, I wonder why. Maybe because it was just straight up witness intimidation and coercion. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the Fifth." Glanville excused the jury, then advised Mr. Copeland in open court that he was in contempt and ordered him to be jailed until Monday, June 10th, at which time Glanville told Mr. Copeland that he would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Glanville indicated he would revisit the issue with Mr. Copeland on Monday, June 10th at 8:30 a.m. and court was adjourned for the day. On June 10th, 2024 at approximately 9:10 a.m., Glanville met with the counsel for the state, Adrian Love, and standing counsel for Mr. Copeland, Caleb Bumpus. The meeting took place in Glanville's chambers. Counsel for the trial defendants did not participate in the meeting and were not aware the meeting was taking place. The transcript reflects that Ms. Love told Glanville that she wanted the meeting to impress upon Mr. Copeland the risks of refusing to testify and allow Mr. Copeland to ask questions before he testified. Ms. Love also expressed concerns to Glanville about Mr. Copeland's representation, which Ms. Love had zero business making those accusations. Ms. Bumpus, Ms. Love, and Glanville also discussed the scope and effect of state's grant immunity to Mr. Copeland. Mr. Copeland was then brought into Glanville's chambers where he spoke with and asked Ms. Bumpus, Glanville, and Simone Hilton, counsel for the state who had joined the meeting during that time.
Oh, this was the hidden meeting that was talking about, that the defense was talking about.
When they had defendants in the case, not just the 6 currently on trial. Complete shit show. They can say they were just explaining to him his immunity deal and, you know, just making sure he knew. This is witness intimidation. They're scaring him into testifying. Glanville discussed OCGA 24-5-507 with Mr. Copeland and his rights and responsibilities after a grant of immunity.
So, like,
Mr. Copeland
really, like, when y'all really think about it, like, when Wooda got on the stand, it really shook the whole case up. Literally, like now they only got the
counsel
judge.
Ms. Bumpus and then advised the court that he would testify. After the meeting, immediately before Mr. Copeland was brought out to testify, defendant Williams' lawyer Brian Steele advised the court that he was aware of the in-chambers meeting. Mr. Steele objected to the ex parte meeting, and a lengthy colloquy occurred between Steele and Glanville, in which Glanville inquired how Steele became aware of the chambers meeting, and Mr. Steele declined to reveal source of information. Glanville held him in contempt, though Mr. Steele was allowed to remain in the court on behalf of his client, defendant Williams. Ultimately, Kenneth Copeland did testify on June 10th and later released from custody. The next day, Glanville issued a show cause order requiring everyone present at ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to the defense counsel. An amended show cause order was later entered setting July 1st as an in-camera review of the transcript and ex parte meeting. Kendrick motion seeks to recuse Glanville because of the improper and coercive ex parte meeting with the state. June 14th, Glanville denied the motion. Glanville determined the recusal motion was timely, supported by an affidavit, contains assertions of fact to support the allegations of bias and partiality. However, Glanville ultimately determined that because there was no way to verify.
Comment, don't even comment the timestamp. If y'all think Young Thug is being the case, just spam hell yeah, like HY type shit. Like, just spam that bit. Because me personally, look, I'm going to be completely honest with y'all. I think Thug is going to beat the case, right? The most he get is 5 years. The most, if he doesn't beat the case. That's the most. You know what I'm saying? Because it's just, the case doesn't make sense. The case doesn't make sense, right? And they're trying, damn, my tank top look crazy. And they trying their best. They trying their best to indict, bro. And they've been supposedly building this case since 2011, 2012, I want to say. And they still ain't pressed no hard evidence against this man. Come on, bro. Put your head in the game.
Verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion. During the in-chambers meeting, the affidavit was legally insufficient, and the motion to recuse did not require a referral to another judge for consideration. June 14th, Bumpus filed a motion to quash the show cause order and recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus resulting from alleged disclosure of the ex parte meeting. June 17th, Thug filed a motion to recuse Glanville. Mr. Williams' motion supplement also seek to recuse Glanville because of his involvement in the ex parte meeting. Divorce from its hyperbole. Wait, hold on. So Ms. Krause is saying it's over-exaggerated. Mr. Williams' motion and supplement also seek to recuse Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. Alleges both actual bias and the appearance of bias because Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became embroiled in a controversy when he held Mr. Williams' lawyer, Brian Steele, in contempt. On July 1st, the day appointed for parties to review a redacted transcript of the ex parte meeting, Glanville announced that he was releasing the entirety of the transcript of the ex parte meeting, and he was taking judicial notice of making a record regarding certain matters associated with the ex parte meeting. Most of what Glanville relayed was a collation of record evidence about the recent circumstances in the case. Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Glanville explained the court's purpose and concern in pursuing the information about the security and confidentiality of his chambers. Glanville was just freaking out that somehow this got to the defense. Oh no, y'all found out about this illegal ex parte meeting. Oh no. Glanville advised that he had not instigated an investigation into surveillance footage but had reviewed such footage for timeline and security. Glanville then explained his view that an ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such meeting. Whatever, dude. Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Oh, really? The state's star witness didn't want to testify. Then this meeting occurs. Now he wants to testify. I wonder why. No tactical advantage. Glanville also questioned defendant's right to be present at an ex parte meeting.
That's where they messed up at. He already, when he got on the stand, he already pleaded the fifth, right? So it would have been smarter for them to just take that one chin up. You know what I'm saying? Take it chin up and just say, all right, we just gonna have to try this case without our star witness. You know what I'm saying? Because now with the star witness, with their star witness being gone, or with them trying to double back like that, it shit made it super obvious. Come on, bro.
Discussion was between the state and a witness who was represented by counsel. After making this record, Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Kendrick, Mr. Williams, and Bumpus were being referred for consideration by another judge in accordance with the Uniform Superior Court Rule 25.1 through 25.7. The motions recused were assigned to this court for consideration. Legal framework. Motions recused are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking refusal must file a timely motion supported by affidavit. The affidavit must be definite and specific and describe extrajudicial conduct or statements which demonstrate bias or favor of any party, a systematic pattern of prejudicial conduct towards persons similarly stated to the moving party which would influence the judge and impede or prevent impartiality. Sounds like Judge Glanville to me. USCR 25.2. Bare conclusions and opinions are not legally sufficient to support the motion or warrant further proceedings. It is the duty to the assigned judge to temporarily cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit. USCR 25.3. If all three criteria are met, the motion is timely, the support affidavit, and the alleged facts might warrant recusal, another judge shall be assigned to hear the motion to recuse. When considering a motion to recuse, the assigned judge should be guided by Rule 2.11 of the Revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceeding where their impartiality might reasonably be questioned. So here we go. Here's what Ms. Krause has to say about everything. Analysis and discussion. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit, and transferring the cases to another judge for consideration, that recusal might be authorized if the alleged facts of the motion were assumed true. Therefore, Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It is worth noting that this court agrees generally with Glanville's assessment of the propriety of the ex parte meeting. Oh, so Ms. Krause is like, nothing wrong happened in the ex parte meeting. Okay, dude. So why is she doing this then? Well, the meeting could have, and perhaps should have, taken place in open court. Nothing about the fact of the meeting or the substance discussed was inherently improper. However, in his order denying Kendrick's motion in the process of making his record on July 1st, Glanville added facts, provided context, and questions.
If you get resigned, like as a judge, do you lose like some of your money or some of your salary, or you know what I'm trying to say, or do you lose your job or some shit like that?
The veracity of allegations, and otherwise explained his decisions and actions and argued why those actions were proper. While it may be appropriate for a judge to disclose information relevant to his potential recusal, disclosure must be made in a way that is objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. And presenting his record as to the recusal motions, and in ruling on Kendrick's motion, Glanville evaluated and accepted the truth of his own factual allegations, mandating his recusal. This court has no doubt that Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. No surprise, Ms. Krause thinks that Glanville could be fair and impartial. Maybe it's because of that $2,000 was sent to you. Necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. So she's just doing it because of the public's confidence in the judicial system. That's it? Just because they're scared of backlash from the public? That's what that says, right? Yacht Gotti's motion to recuse granted. Caleb Bump's motion to quash the show cause order is denied. Williams' motion to disqualify recused. Judge Glanville granted. Rachel Krause. Bradford Cohen says the handling of this case is shameful. There has been no justice. Judge Glanville should be referred to the JQC. The fact that he was clueless as to an ex parte communication was mad it was revealed instead of making the correct ruling is shocking. Young Thug deserves a bond at this point. This has been dragged way too long. What's the likelihood of this case being thrown out due to prejudice and the lack of a fair trial? See, that's what the defense lawyer is going to go after next. Brian Steele's statement regarding the recusal order. Jeffrey Williams is innocent of the charges brought in this indictment. Clear his name, he sought a speedy trial, one in which he would receive the constitutional guarantees of a fair trial with an impartial judge presiding and ethical prosecutors following the law. Sadly, Glanville and the prosecutors have run afoul of their duties under the law. Mr. Williams is grateful that the reviewing court agreed with him and entered the order recusing and disqualifying Judge Glanville from presiding over Williams' case. We look forward to proceeding with the trial judge who will fairly and faithfully follow the law. And here's the new Judge Ingram right here. Apparently this trial is going to go on, but I'm sure defense lawyers are going to be following some motions to dismiss. It's kind of funny how the jury has just been at home waiting pretty much, or at work. Who knows? I don't know how they still have a fucking job. Yeah, clearly the jury has seen all this nonsense online. That's just common sense in my opinion, but I'm sure there's going to be some motions here in a second with this new judge, so I'll be covering it like always. Hit subscribe. I really appreciate every single one of you. I'm going to start making weekly bonus videos on the membership. Once a week, I'm going to put up like a bonus body cam reaction of me watching a body cam footage maybe, or talking about the YSL trial. Who knows? I would really
I was thinking something else. I don't know where I'm at. But nah, so that's the update, bro. I want to follow it, but it'd be too much going on. So I need a little update because I seen the update going crazy. So like, comment, subscribe. If you're rocking with new, like, comment, subscribe. If you're new, you know what I'm saying? Let's get to 2K and I'm out. You did.